I'm going to introduce Oliver, who, when I said just then, how would you like me to introduce you? He said politely, which I thought was wonderful. But I think Oliver's like a caped crusader who, has an invisible cape going around protecting people's rights when nobody's looking. But he's a barrister at Doughty Street Chambers. You've got international record, having a huge passionate advocate of the UNCRPD. And shall I hand over to you to do a better, more fitting introduction?
No, I'm not going to do a more better or fitting introduction, because that was full of superlatives, which I'm very grateful to you, Kate. Hopefully everyone can see the screen.
There we go. So I think we're on your presentation. You can see your notes. I don't know whether you want us to see that.
Oh, really? That's annoying. Hang on. What about that?
Perfect. I shall turn my video off and leave you to kick ass, Oliver.
Right. Thank you very much. So good morning, everyone. Thank you very much for joining this session. It's a real pleasure to be here with everyone. And one of the annoying features, obviously, of COVID-19, apart from the very large number of people who have very sadly died, one of the annoying features is that we don't get to meet people in person, and I'm really missing that. But one of the good features is that it's, in a sense, democratized the availability of information. So I've spoken and done a lot of webinars during the past few months, and have spoken to way more people than who could actually, get to whichever city we would actually be in. So I'm really grateful that, Kate, you've decided to switch your advocacy conference online and have pulled together such an incredible number of amazing advocates from such an array of places. So one of the topics that Kate and I thought would be interesting for you is the United Nations Convention on the Rights of Persons with Disabilities. So what I intend to do over the next hour, and there'll be time for questions and answers. And Kate, by the way, if anything pops up in the chat, which I'm not going to be monitoring during my presentation, if you think that there's anything worth chipping in, just unmute and say it. We can discuss it as we go through. I don't mind that at all, rather than waiting until the end.
Fabulous. I shall do that.
So one of the curious things for me is that having worked in international human rights law and the whole kind of ecosystem of international human rights for 15 years and being based in Budapest until 2015, I was working for an organization that we did a lot of advocacy, litigation, training, monitoring of closed institutions, etc., mostly in Central Eastern Europe and 3 countries in Africa. And as you'll see in a moment, we always used, and people still use, the UN Convention on the Rights of Persons with Disabilities, which I'll call the CRPD. We always use the CRPD as the basis, the key document, which contains the rights of disabled people, and used it as an analytical lens and the document from which to call for change. But not so in this country, and I think that's remarkable. It's explained by the fact that the convention is not domesticated. We'll come on to that in a moment. But really, this session is to encourage you all to use it in your day-to-day work, because it's a piece of binding international law which applies in the UK. And it doesn't just apply in the UK, obviously. It applies all around the world. So here's a map of those countries which have either ratified the convention or signed it. There's an optional protocol to the convention, which is an additional document that sets out the right for a person in that country who thinks that their CRPD rights have been violated to take an individual complaint to the CRPD Committee, which we'll come on to in a moment, which periodically meets in Geneva. So it's a complaints mechanism, and it also enables the CRPD Committee to conduct an inquiry if there are grave and systemic human rights violations. And the CRPD Committee has conducted an inquiry into the effects of austerity in the UK, and it published its report in March 2017. So that's the optional protocol. So you'll see there that there are lots of countries which are dark blue, which have ratified the convention but not ratified the optional protocol. And there are loads of red countries which have ratified the convention and the protocol. So in fact, most countries in the world, 175 ratifications of the convention, and another 92 countries which have ratified the convention and the protocol. Actually, I'm just going to put this in the chat. If I can, oops, managed to. How do I reach the? Okay, here we go. That's funny. I can see Q&A now, but I can't see. Oh, there's chat. Right. Blimey, this is okay. Let me try and send that. So you should see a hyperlink there. If you just want to click on that link, you'll see the convention, which you may want to have open on your screen as we go through. So main message of this slide, the convention has global reach. And you can see there that UK is a red country. It's ratified both the convention and the optional protocol. One of the countries which has not ratified the convention is the US. For various political reasons, the US has a troubling relationship with international human rights law, but who knows what might happen in the future. This is a picture of the negotiations that led up to the adoption in December 2006 by the UN General Assembly of the CRPD. And I was involved in the negotiations as part of the NGO, which I used to direct, alongside 500 other odd NGOs. So disabled people, as diplomats and as representatives of civil society, had a huge impact on the negotiations, which were the fastest in history. So the CRPD, out of all of the UN human rights treaties, is the fastest negotiated in history. It took only 4 years for it to be negotiated. That sense of participation and inclusion of people with disabilities in the process leading up to the adoption of the convention has made it into the text of the convention, and is one of the sort of what participation has been described as the lifeblood of the convention. It's a core principle going throughout all of the provisions of the convention. So how does the convention work on the ground? Well, here's a picture I took covertly in a psychiatric hospital in India a few years ago. This is a ward. The label of the ward was for people with epilepsy, but I soon learned that it wasn't really true. This was a ward for people with, as far as I could tell, maybe mild learning disabilities, some people who'd had mental health issues. And they were incarcerated in those conditions for weeks and months at a time, and given medication and a bit of food, and that's it. And so this is typical. This is the state of mental health care in many countries in the world. This is obviously a closed institution. You will be many of you who are statutory advocates in the UK will also be used to visiting closed institutions, which may look significantly different to the photograph on your screen, but I would say have more similarities than we might actually think. And in India, just as an example of one country, a pretty big country, there are incredible civil society organizations, NGOs which are advocating for changes to the mental health and social care system in that country. And I've been lucky enough to be involved in some of these advocacy initiatives. This is a picture of a roundtable event that we held in 2013, and it was looking at torture and inhuman and degrading treatment of people with disabilities in India. And there are a number of incredible Indian activists there. I think the photo is kind of a bit unfortunate that the white man, it has the microphone, that's me by the way, has the microphone and is speaking, but just to reassure you that it was my turn to speak and everyone else had an opportunity to speak. But the point I want to make about this photograph is that we were talking about the CRPD and how India has ratified the CRPD, and that therefore it has obligations under international law and to the people in India to make changes. One of the provisions in the CRPD, as you'll see if you're flicking through it, is in Article 16, and it talks about exploitation, violence and abuse of people with disabilities. You can also see a prohibition of torture and the promotion of mental and physical integrity in Articles 15 and 17. So we were pinpointing those provisions, as well as the article on non-discrimination, Article 5, to give NGOs in India an opportunity to use the CRPD in their local advocacy. And I've done sessions in India where I've been driven for 2 hours outside a city, and we go to a very rural village where I've been greeted as some kind of VIP, and there's signs and there were chairs laid out, and there was a podium. This is all outdoors, and everyone who could from the village came and heard me speak about, as well as Indian activists from NGOs, about mental health care in India, and we were talking about the CRPD in a village in India. And now there are people all across India who are talking about the rights of people with disabilities being violated, and the thing that they're talking about is the CRPD. So another very recent example of how the CRPD is being used is this fantastic report that Human Rights Watch have done. And I'm going to copy and paste the link there. So this is a report. They looked at over 60 countries and found this global phenomenon of shackling, of tying people, chaining people with labels of, I mean, very loose labels of mental health issues or learning disabilities. Clearly, it's not diagnostic led at all. It's simply, shackling is simply a means of control, and clearly it's abusive. And one of the lenses that the Human Rights Watch team use is the CRPD, because that's what has global currency. Finally, just to drum this point, this preliminary point home, the CRPD is recognized at the UN as one of the means of achieving the SDGs, the global, the Sustainable Development Goals in the 3030 agenda. And there's lots of reports, documents that you can read about in terms of how the CRPD and the implementation of the CRPD is supporting inclusive development programs around the world. And so that's really linking the implementation of, or the achievement of human rights with the reduction of poverty and reduction of inequalities, economic and social inequalities. So preliminary point over that point was to emphasize that the CRPD isn't an obscure technical document which you may have heard of. No, it's the #1 primary source used globally by the UN down to national governments, to NGOs and small villages. It's the #1 document setting out the rights of disabled people and how those rights can be achieved. Right. One of the things I said that we come back to is this body called the CRPD Committee. And this is a committee composed of 18 experts from different countries who don't get paid, but they're elected by the governments of governments that have signed, that have ratified the CRPD. And the committee meets twice a year, these days virtually, in sessions of 2 or 3 weeks. And the committee has various different roles. They periodically examine each state that has ratified the convention, and produce documents called concluding observations. So the committee examined the UK in 2017, and in October produced a document called the concluding observations on the UK. And I'll point to some of the observations that the committee has made. As previously mentioned, the committee can also produce inquiry reports under the optional protocol, and under the optional protocol can adjudicate individual complaints. So it sits as a quasi-judicial body, if you like.
That's a nice question.
Sorry,
Oliver, this is where I'm interrupting. We've had great question from Tanya come in. Can advocacy, or how can advocacy organisations kind of engage with submitting information to the committee when it reviews the UK? Yeah,
really good question. So in 2017, there were lots of NGO reports from the UK. And also the Equality and Human Rights Commission did a report. There were lots of civil society, activities and activism around that time. I don't think the next examination of the UK has been scheduled yet. It's roughly every 4 years, but I think there's significant slippage actually. So there you will find out. There'll be no doubt that this will be very well publicised within the UK disability rights community, and there'll be plenty of opportunities to feed in information to the committee at that stage. I hope that answers the question. So just to finish off, this slide off, the committee can also produce what they call general comments, which look at a bit of the convention, a right, and they explain what that right is. And if you click on the link which I sent, which has the text of the convention in the middle, you'll see on the left-hand side, I think there's more information about the general comments, about the sessions that the committee has, about its work in general. So you can kind of snoop around there on their website. Right, so that's the CRPD committee, people from all over the world. They gather together, 18 of them, and they meet in Geneva occasionally. But what about the UK? So the CRPD was adopted by the UN General Assembly. And by the way, the UK played an important role through the European Union in negotiating the treaty. And the UK ratified it quite rapidly in 2009. So it's been ratified for over a decade in this country. And it has a curious status here, because unlike the European Convention on Human Rights, the ECHR, which is embedded into UK law via the Human Rights Act, as you probably know, the CRPD isn't. There's no CRPD Act, right, which would transmit or embed the CRPD into English and Welsh law. Another word for that is incorporation. However, it has been ratified by the UK, it is a binding piece of international law. It's a treaty. And here's just one example of a case that says that it can be used as an interpretive aid. So if there's a doubt as to a piece of UK legislation or some case law, then the courts can use the CRPD to assist the court in an interpretation of that law. And the case of Davey a few years ago, that's the key case on that point. As a bit of a fan of the CRPD, I often use the CRPD in my submissions to the in judicial reviews, in public law, in the Court of Protection very often, and in other fora. And recently there's a case, you can Google it there, where some of my submissions were taken up by the judge and it made it into a judgment. So it's one of the rare cases that the Court of Protection has a reported judgment where, and I was arguing Article 19, which we'll come on to momentarily. I was arguing there that the court can take that into consideration, can take the right to live independently and be included in the community into consideration in its best interest calculation. So if the courts can use it, if the UK government has ratified it, then my suggestion is that advocates can also use it. You can use it in your day-to-day work. I often see in Dole's forms reference to European Convention on Human Rights. Even case law is sometimes kind of copied and pasted into best interests assessments in Dole's form 3. Sometimes even the case of Stanov and Bulgaria is mentioned, which I was also involved with, which is great. I've not yet seen the CRPD being mentioned in any Dole's papers. So please, could someone in this webinar make history by talking about CRPD rights, perhaps in either in a witness statement or in an assessment. So what does the CRPD say? I've given some clues already, and you may even have it on your screen. So some of the key concepts, and if you look at Article 3 on the key principles, you'll see some of these principles listed, but these are so important. So it talks about full and effective participation in society. And note the words, it doesn't talk about, participation matching someone's ability, or reasonable participation, or depending on resources, whatever participation the state can afford. It doesn't say that. It says that people are entitled to full and effective participation. Inclusion is one of the key concepts, as is non-discrimination, including a failure to provide reasonable accommodation. That's the wording that's used in the CRPD. Reasonable adjustment is used in the Equality Act, but more or less the same thing, as well as accessibility. So those key concepts run throughout the convention, and the convention applies to persons with disabilities. And I note that in the UK, there are some activists who say, oh, that phrase is horrible, it is insulting. That's the phrase which is used in the convention and used by global disability rights activists. But I understand in the UK that some people prefer the term disabled people. I make no judgment on that. I'm simply using the wording that is used in the convention and is used by the CRPD Committee and by global disability rights activists. So the CRPD says that persons with disabilities include those who have long-term physical, mental, intellectual or sensory impairments, which in interaction with various barriers may hinder their full and effective participation in society on an equal basis with others. That's really interesting. So let's just dissect it a little bit. First thing to point out is this curious phrase, long term. Well, governments wanted to put that in the negotiations, And the NGOs said, well, first of all, what does it mean? And why is it relevant? Why, if the impairment is short term, why shouldn't the convention apply to that person who is temporarily a disabled person? But the states won, the governments won the argument, but NGOs managed to include the word include, right? So it doesn't say persons with disabilities are those who have long-term physical blah, blah, blah. Persons with disabilities include, so it's non-exhaustive. So it includes those people, but it may include others. And so that could be, for example, tested in a court. And then the second curious thing, for me at least, is this word mental. So if you read it, you've got physical impairment, intellectual impairment, sensory impairment, but you've also got mental impairment. What does that mean? No one says that. That's not a psychiatric phrase. It's not a law phrase. It's not a social work phrase. No one says mental impairment to mean in the Mental Health Act, a mental disorder, or to mean a mental health issue, mental health problem. So it says that in the convention, but no one says that. The CRPD committee doesn't say someone with a mental impairment. Global human rights activists don't use that phrase either. The phrase that is preferred and has been used the moment the convention was adopted is people with psychosocial disabilities. So that's the phrase that means, in the UK, one might say people with a mental health issue or mental health problem, and so on. The first part of the sentence is about impairments, but the disability arises, it says, and this is social model disability stuff, right? The disability arises not because of the impairment, but because of the interaction of the impairment with the disabling barriers. And elsewhere in the convention, in the preamble, it talks about environmental and attitudinal barriers. But there are other barriers also. I would say that there are significant legal barriers that cause people to be disabled from full and effective participation in society. And then we've got the phrase, my last point of dissection is on an equal basis with others. And that phrase occurs about 150 times in the convention. Okay, maybe not that many, but a lot. And it's important because that's the comparator, not with, it doesn't say with non-disabled people. It says on an equal basis with others. So you've got the person with disability, the one person who's claiming their rights under the convention, and their rights have to be looked at in comparison with others. So it could be other disabled people, other people with different disabilities, or other people who don't have disabilities. And I kind of like that, this phrase, because it doesn't pit disabled people against non-disabled people, if you like, which the Equality Act in this country does. And the CRPD makes this point, but it also makes another point in the preamble very beautifully, saying that people with disabilities are part of the of human diversity and should be celebrated. This is it's a celebration. The CRPD, if you like, is a declaration of independence for disabled people, or some might say a declaration of interdependence. So those are some of the key concepts that, in my view, you can use. I use these in litigation, and NGOs around the world use these points in reports to the CRPD Committee, in advocacy to their local, to their own parliaments, and so on and so on. So I just want to hone in on 3 key rights that I think you as advocates can and in my submission should be using and advocating for the rights of your clients. And those rights are legal capacity in Article 12 of the Convention, the right to live independently and to be included in the community in Article 19, and the right to life in Article 10. And the reason I'm going to talk about the right to life is because I want to make the point about COVID-19 and the sense of urgency that I don't see in social care and in advocacy in this country. And I just wanted to make the point that you can use human rights to protect the life of people in congregate settings who are obviously so much more at risk. So first on legal capacity, that's what the convention says. I'm not going to go through all of that. This was one of the most fraught points within the negotiations that led up to the CRPD being concluded. And it's really paragraph 2 there that, in my view, is in a sense the executive summary of the whole convention, that people with disabilities shall enjoy legal capacity on an equal basis with others in all aspects of life. So if you, it's like, and if you think about the convention as an onion, peel away all of the layers of discrimination and exclusion from education and denial of healthcare and gender-based violence and all of that. You peel away these layers, and at the core, in the middle, in my view, is Article 12.2 there, that people with disabilities have legal capacity. They have rights. They have rights which should be recognized by the law, and that they have wishes and feelings and autonomy. But the convention doesn't say that people with disabilities should always make decisions by themselves. That would be unrealistic. So if you look at the next bit, paragraph 3, it's got a positive duty here on states. It's telling states that, states means governments, states that that there needs to be access for people with disabilities who may require it to exercise their legal capacity. So that includes decision making. So access to what the international community is now called supported decision making. So instead of a regime like the Mental Capacity Act, which says, let's test you to see whether you have mental capacity because it's like a light switch, it's either on or off. Let's test you using the test with which you're all very familiar in the Mental Capacity Act. And, oh, you don't have capacity to make this decision. So therefore, let's hand over that decision making to someone else. The CRPD takes a completely different view. It says that actually the Mental Capacity Act is not in compliance with Article 12, far from it, and that actually the assessment should be about whether the person needs and wants assistance, support in exercising their legal capacity. And then there's an obligation on the state to provide that support. And that's where advocates could, in a different legislative regime, play such an important role. So very much the emphasis here is not on removal of capacity per the Mental Capacity Act, but on bolstering people's rights to exercise their legal capacity, whether that's through vocalization or the blink of an eyelid or whatever. And paragraphs 4 and 5 there are really about safeguards, and those need to be read in conjunction with Article 16, which sets out the right to be free from exploitation, violence, and abuse. So what does all of that mean? Well, the CRPD Committee, in their concluding observations to the UK in 2017, has made these points. It said that the prevalence of substituted decision-making, which is what the MCA is, it hands over its proxy decision-making. The attorney or the deputy or the best interest decision-maker, could be a court, that's a substitute decision-maker. So the CRPD is saying that that prevalence of that and the lack of recognition of the right to individualized support decision-making that respects the autonomy, will and preferences of persons with disabilities. It goes on to say really doesn't match the requirements of Article 12. It notes the high number of Black people with disabilities who are compulsory detained and treated against their will. And it really makes the point that one of the ways that legal capacity is denied is through the operation of the Mental Health Act, which removes people's rights. People become entirely powerless once they've been diagnosed and sectioned. They really have very few rights, actually, in reality. The committee urged the UK to step up efforts to foster research, data and good practices in the area of and speed up the development of supported decision-making regimes. I don't see that happening, really. I mean, there are some pilot projects. Looking at how supported decision-making can become more embedded, but I don't really see the UK government fostering research and data and good practices. And the committee says that noted its concerns that people with psychosocial or intellectual disabilities were not receiving appropriate support in exercising their legal capacity and access to justice. And I thought for the purposes of this presentation today, that's really important for you. You play a key role in supporting people to exercise their legal capacity and facilitating their access to justice. So those are some points on legal capacity. I note that someone has said that that's unrealistic. If I'm unconscious, I can't blink my eye. Yes, absolutely. And the CRPD Committee in its concluding observations talks about the best interpretation of someone's will and preference. There are no easy answers, but there's quite a lot of heavy lifting in terms of thought going into figuring out how Article 12 can be operationalized in reality. So moving on to the second of the three rights I wanted to highlight, living independently and being included in the community, which is one of my favorite rights. If you are interested in this, I've co-written quite a lengthy article which came out a few months ago in the International Journal of Law and Psychiatry. I'm happy to send it to you. If you want to either email me, you can Google my email address or notify Kate. I can make that available. This is a really interesting, very important right, which is potentially transformative. So in a nutshell, Article 19 says that governments need to legislate to recognize that people with disabilities have the right to live in the community, and places an obligation on states to ensure that the states are taking effective and appropriate measures, so action, to facilitate the full enjoyment of this right and to facilitate people's full inclusion and participation in the community, right? That's what governments have to do. Is the UK government really doing that? Taking effective and appropriate measures to facilitate people's full inclusion and participation in the community? I think many people would say not really. And then A, B, and C are just illustrative. They are compulsory actions that governments must take. And we know that because of the wording, including by ensuring that. Yeah, so governments must do A, B, and C, but there may be other things that they could do usefully as well. So A sets out the right of everyone with a disability to choose their place of residence and where and with whom they live on an equal basis with others, and are not obliged to live in a particular living arrangement. So the convention doesn't use the word institution or institutionalized setting, but this is but it was clear from the negotiations that this is the opposite of Article 19A is sticking someone in an institution. An institution can be labeled as many things, so mental health unit, ATU, care home, supported living is often have institutional regimes, in my view. and people are plonked in these places even if they don't want to be there. So Article 19A is saying that no, that can't be right. People shouldn't be obliged to live in particular living arrangements, and they should have the choice about where they should live. Importantly, on an equal basis with others. So if I choose to live in Buckingham Palace, there are constraints around our decision making, and on an equal basis with others, I don't get to choose to live in Buckingham Palace. B talks, this is really about individualized and tailor-made supports, so disability-related supports, whether that's in-home, residential. So it could be that someone chooses to live in a residential setting, but really the emphasis here is on community support services. That's the key phrase, including personal assistance, very important for billions of people with disabilities around the world. And these individualized support services, if you look at B there, the purpose of them, it says, and this is a really important point, is to, if you look at the last bit, is to prevent isolation or segregation from the community. So segregation from the community could be in a faraway institution, an ATU, 100 miles away from where the family lives, for example. Prevention of isolation in the community could be that someone's in the community in their own home, but because they don't have the means, the access to the community, they're isolated from it. And we've all got examples from austerity to illustrate what that can mean. And then C, Article 19C, is the sister of Article 19B. It's the other side of the coin. So whilst B is about individualized support services tailored to the person's needs, C is about access to services which are available to the community, making sure that transportation systems, housing stock, employment services, any community services and facilities available to the general population, those need to be available on an equal basis to people with disabilities and responsive to their needs. So so both B and C have a transformative potential. And 19A is clearly linked to Article 12 on legal capacity because it's about choice and the realizations of that choice and about reducing coercion and control. And so what did the CRPD Committee say about Article 19 in the UK? It said what you already know, which is that there's no law setting out that people in the UK have the right to live independently and be included in the community. That it made the important point that responsibility for supporting independent living has been delegated to the devolved administrations and in England to the local authorities. So there's the delegation, but there hasn't been what else is required, which is a budget to do that. So local authorities have the duty under the Care Act to provide services and meet people's needs, but the CRPD Committee is saying that central government hasn't provided enough dosh for them to do that. It's also made the point that many disabled people are still institutionalized, and we know that, and deprived of their right to live independently and being included in the community when they lack the financial resources to afford personal assistance, when local authorities take the view that they can provide assistance within care homes, which is anathema to Article 19, and that the cost rationale constitutes the main parameter of an assessment. Now, we all know that. So, roughly speaking, if your needs can't really be met by 3 or 4 care visits per day, oh dear, you have to go to an institution because that's the cheapest means of meeting your need. And that's a violation of Article 19. So, so how can you use Article 19? I mean, there are various things that you can say in your assessments and in your notes and in your advocacy. You can use these phrases that the person is being denied their right to live independently. I mean, they have the right under the CRPD, that support services are unavailable or inaccessible or unaffordable or unacceptable or unadaptable or insensitive to the living conditions of that person. You can make observations that there's no local strategy for social support and living independently. You can make the observation that the local authority doesn't have funding to enable your client to live independently and be included in the community, and is denying them their right to choose their place of residence and where and with whom to live. That's wording of Article 19. And you can make observations that there's no local plan aimed at the deinstitutionalisation of disabled people, no community-based independent living schemes with input of other sectors such as education, childcare, and so on. And that's wording from the CRPD's concluding observations on the UK in 2017. So Article 19 is an incredibly rich tool for you to use in your daily work, especially those of you who are working with clients in hospital settings and in care home settings or other institutional congregate care settings. I want to finish on congregate care settings by making the point about the right to life, which is obviously in Article 2 of the European Convention and pretty similar wording in Article 10 of the CRPD. And as you may know, the right to life has what we call negative and positive duties. So there's a negative duty on the state to not do things, like the state is not allowed to go around killing people. Good news, but the state also has positive duties. So these are positive duties, actions that the state must take when there's a recognized or an arguable threat to life. Obviously, COVID-19 is a threat to the lives of potentially all of us, but people with disabilities, and I include older people with dementia, as well as people with intellectual disabilities, are at a dual risk, that people in congregate care settings are more at risk of contracting the infection. And we know because of medical research that older people are more at risk of a worse outcome if they get COVID-19. And we know that because of comorbidities, disabled people, including people with learning disabilities and autism, are more at risk of a worse outcome. And that's because of comorbidities such as diabetes, obesity, cardiovascular disease, and so on, which have a higher prevalence rate in people with disabilities. And also, we know that COVID-19, if people with those comorbidities get COVID-19, they suffer from worse outcomes as well. So one of the points I want to make is that advocates are involved in supporting people who are deprived of their liberty under the DOLS regime, under Schedule A1 of the Mental Capacity Act. And that a standard authorization under the DOLS regime can only be put in place if it's in the person's best interests. And the best interest calculation, as you all know, has to be informed by the relevant circumstances. There's a duty on the decision maker, in this case, the local authority. The decision maker must consider all the relevant circumstances. And clearly COVID-19 is a relevant circumstances. It would be an absurdity to argue that it's not relevant. And we know from international law that the state, in this case, the local authority, which is the detaining authority, is obliged, has a duty to take steps to prevent a deprivation of liberty under Article 5. And we know, because I've just mentioned it, that the state has a parallel obligation to take steps to prevent threats to life. And we also know that deprivation of liberty is only lawful if the best interest qualifying requirement is met. And so, in my view, there should be a massive increase in Section 21A applications that challenge the standard authorization. But during the COVID-19 pandemic, we've seen the reverse, which I find remarkable. We've seen a downturn in Section 21A applications at the very time that thousands of people are deprived of their liberty in situations that they don't want to be in, that they're objecting to, but now because of COVID-19 that pose a threat to their life. So I would say that advocates need to be kicking up a fuss about this in order to prevent the loss of life. And this point has been made by numerous people at the international level. I won't go through all of this, but there's this concept of emergency deinstitutionalisation in order to save life. This requires the state, the local authority, to go through their list and make sure that everyone who can leave an institutional setting does leave, and to fund community-based care, and also for people on the brink of being institutionalized to do everything possible not to transfer them to a care home. So to inject cash at the local level to bolster the community-based support services so as to prevent institutionalization. The UN Secretary General has said that there needs to be a reduction of people in institutions, and he's called upon states to take immediate action to discharge and release persons with disabilities from institutions wherever possible. Deinstitutionalization strategies need to be accelerated and reinforced with clear timelines and concrete benchmarks. So I think that advocates can play an enormously helpful role in ensuring that each local authority in the country is doing this. So in summary, I think that the CRPD has lots of useful concepts for you and lots of relevant rights for your clients. Even though the CRPD is not incorporated into the UK law, you can use it. It's in use in social care. It's in use in the Court of Protection. I've highlighted 3 rights, which I think can be useful to you and your clients: the right to legal capacity, the rights to independent living and being included in the community, and the right to life, which is particularly important in the pandemic. Thank you very much. I'm going to stop sharing my screen there.
Fabulous. Chatter is wild. Okay, we've got 4 minutes. Chatter has exploded. I'm going to fire some questions if that's okay, Oliver. Couple of specifics around using the CRPD to challenge, and I don't know whether people have quite got that idea that you can't use the convention to kind of legally challenge, can you? If you're thinking of the legal challenge, is it better to use the Human Rights Act?
Yep. Yeah. So, I mean, you can use it to support Human Rights Act claims. I do that. I use it to support Human Rights Act claims. I use it to support Equality Act claims. You can use it in Section 21A applications. So it needs to be in support of argument. This is a legal point, not a lay advocacy point, really. The lawyers use it. Well, first of all, lawyers don't really use it. Only a bunch of us, a handful. Lawyers can use it, or for example, the Convention on the Rights of the Child. Similarly, they use the CRC to bolster ECHR or domestic law arguments. Got you.
Because there was a few, just to give you a few examples. One was around if a person with a rare disease isn't receiving funding from the CCG. Another example was disabled people not accessing healthcare and the kind of discrimination that we've seen in COVID of preventing people from accessing healthcare. And then the other one was around disabled people in support and living being subject to more restrictions than perhaps, you know, their non-disabled counterparts. And that, like, so the example given was being told they can't visit a partner when everybody else can. So in those instances, I suppose the advice from yourself would be to use the CRPD to support what they're saying and to use it in that way.
Yeah, absolutely. I think my main bit of advice is on all of those issues, including the visiting issue, which I've done quite a lot of work on and done a few challenges, is please kick up a fuss. Go and see a lawyer and demand that the visits are resumed. I mean, there really is very little justification for any blanket ban on visiting in hospital settings, in care home settings, and supported living. So I'm doing another webinar next week. On the, I think, 11th of November, a couple of weeks' time, on visiting people in supported living placements. If you want to know more,
that'd be great. And is it worth plugging the website that you've recently launched?
Yeah. Thanks for plugging it.
Sure. If you got the link to hand.
Yeah, let me just get that. Keep talking.
Just as you're doing that, I was just speaking to somebody yesterday whose adult child is in a mental health hospital, and they've just said, ban a block ban on visits. And I suppose the question is about asking, well, on what basis? Why are they doing that? Because it might be reasonable, if there's a big outbreak of COVID, it might be reasonable to stop visits for a week. But I think this idea of an indefinite, we're on lockdown, that's the bit that needs to be questioned. And then, of course, questions around, well, what's the impact on this individual, and what reasonable adjustments are being made to counter the effect of not being able to see family. And I think as advocates, these are, basic core fundamental questions we need to be asking to make sure that these,
totally.
Go on, if you've done it. Do you want to?
Yeah, I agree. Absolutely. And advocates need to take action. You need to go and see a solicitor, a public law solicitor. And if you need advice on which solicitors might be able to help. So I'm a barrister, and whilst this is not touting for business, but whilst I help people on what we call a direct access basis, really the first port of call should be a solicitor. So if anyone needs any advice about which solicitors might be able to help, feel free to contact me. There really needs to be more action, legal action, and challenges to these restrictions.
Definitely. And I know this session isn't about mental health sessions, but just to say, if you are working with people in mental health sessions, they will have a Mental Health Act solicitor. So you've got a very easy route there to somebody with legal expertise to do it. There's two questions, if I may, if we've got time, Oliver, you.
Yeah, of course, yeah.
One was a really interesting one around supported decision making, and kind of what are your views on when somebody does lack capacity, so they are very unwell, or they cannot make decisions because of their impairment. How do you think decisions should be made? So
under the CRPD kind of schematic, what the CRPD committee would say is that it's about not transferring the decision-making power to someone else, but it's about supporting the person and enabling the person's legal capacity, so that it's about a best interpretation of someone's wishes and feelings. Wishes and feelings is MCA language, but will and preference is the CRPD language. And yeah, people always say, well, what about a person in a coma? They can't express any views. So first point is to say that the number of people who can't express any will and preference is absolutely minuscule compared with the number of people who can. So let's, it's kind of strange to always talk about people in a coma, but for people who have it's not possible to interpret their current wishes and feelings. It's about a best interpretation of will and preference rather than a best interest decision. Yeah, love it. And I think if people are interested in this, I'd refer you to listen to and read anything by Wayne Martin, because he brilliantly, doesn't he, around, and the way I kind of have understood it is we start with what the person would want rather than we start with what we think is in the best interest. Which, and the MCA, I think, kind of it technically allows for both, doesn't it? Whereas we want it to start with what the person would want or what's important to them. But the MCA does say, of course, if a person lacks capacity, the best interest decision maker needs to take into account that person's wishes and feelings, or previously expressed wishes and feelings and values and all of that. But the Act doesn't give primacy to those wishes and feelings. No, just take. It's perfectly legal for someone to say, yes, I've taken into account what you think, but I'm going to do the opposite.
Yeah, yeah. And
And
it's
the CRPD says, no, that can't be true. That's not in compliance with Article 12.
Yeah. Well, if we think about advocates and IMCAs, you know, there's arguably a role there for us to say, well, how have you taken it into account, actually? Or even just say, what was the person's preferences? Because I think sometimes the decision maker doesn't even know what the person might want. And so it's all about questions, isn't it, in advocacy? Yeah. Ask brilliant, powerful questions. And then the very last question, which we could probably have a whole 3-day symposium on, is from it's fascinating, and I've really enjoyed reading Veronique's comments in the chat box, which she's questioning how can we, you know, the problems in psychiatry where perhaps controversial treatments are authorised or non-proven treatments. Can we use the CRPD to kind of challenge that culture, that practice where trauma is inflicted on people and that they're not receiving appropriate care? Any thoughts?
Yes, I think you can use the CRPD in any conversation you have with people. It's there. It's globally relevant. It's supposed to have utility in the village in India, as well as in the psychiatric, you know, ward in your local hospital. So I do think that you know, it's not gonna immediately leverage someone's rights, but you can easily use it as part of the conversation. And it opens out a sort of slightly different way of thinking. But ultimately, it's not going to trump the Mental Health Act and the restrictions that the patient is under if they're compulsorily detained under the Act.
But again, I'm hearing that like broken record of we need to get familiar with the articles. We need to be getting used to quoting from them and using this document. Yeah. And I'm going to give the final question to Chloe. Hi, Chloe. Can you join us?
Yeah, I have one main question really, in that we're hearing a lot about people in care homes and institutions and the reaction to COVID and their rights. But what I'd like to know is what on earth is going on with people who live in the community with support and are not technically classed as living in an institution, but have care coming into their home and require extra precautions and extra support to be taken to protect them from the effects of COVID-19 and to make sure that regardless of COVID-19, they can still access the community and go about the daily lives. Because as a person in that situation, I feel like I've been forgotten. But when you read about the laws and, you know, everything around that, it's all about if you live in an institution, which does not apply to me and many of my friends. Yeah. For example, I can't get a COVID test, nor neither can my team of carers, unless we get symptoms. But surely, if they're considered like staff in a care home, and I'm coming into regular contact with different people, we should be allowed to be being tested on a regular basis. But we're not. It took us about 3 months to get hold of any type of PPE. And until that point, we were expected to fund it ourselves.
Yeah.
You know, we weren't contacted by any form of social services for a good while after we went into lockdown. And when we were, they didn't really know what to do about it.
Yeah. I completely agree. I mean, it was just appalling the way that disabled people in the community, and obviously the vast majority of disabled people in this country don't live in institutions. They live in the community with various arrangements for support. And they were completely forgotten about, as far as I can tell, by the government. People scrambling around trying to get PPE, non-existent, incredibly expensive, no testing, etc., etc. So it wasn't just people in care homes who were abandoned.
And also, I have an issue with the rule of 6.
Yeah.
which I think is violating human rights, because why is a personal assistant or a carer counted as in the 6? Because I couldn't go out to meet my 5 friends without that support, but because they're there, I can only meet 4 friends. And if I've got other friends with PAs, then the number of people that we can actually socialise with drops.
Yeah, good point. You could potentially challenge that, do a judicial review. Can I just say that Article 19 is incredibly helpful for people living in the community, because it talks about individualized support that needs to be, that the state has an obligation to provide, so as to prevent isolation from the community. So it's Article 19 is not just relevant for people currently living in an institutionalized setting. It's about full and effective participation in the community.
I think we know that as advocates, but it's not widely known. It's kind of like, oh, you've chosen to live within the community, so you deal with the consequences of it, to a point where when you approach the social system, their solution is to advise you to move into an institution.
Yeah, exactly, which
that is easier
and cheaper.
You know, I
don't know if you're interested, but Simone has just popped in the chat box that a People First group are looking at taking some action against this, and they're talking about it in the group today. Maybe if we can hook you up. I think everyone's agreeing with what you're saying.
Yeah.
Swap email addresses with relevant people for the case.
Yeah. So, main message from me is use the CRPD, but also advocates, take more challenges, contact solicitors, kick up a fuss, because there are so many injustices happening at the local level that we actually see very few legal challenges. In reality, solicitors are not being contacted, the ones that I know, at the rate that I would expect. There should be loads more legal challenges. I'm not just saying that as a lawyer and I, want more work to do or something like that, but this is a matter of social justice, and these restrictive regulations and regimes and arbitrary decisions very often need to be challenged.
Yeah, without a doubt. We shouldn't be busy, this should be our busiest moment, I think.
Yeah, exactly.
Yeah. Okay, I'm gonna call it there because I've only got 2 minutes now before we start our next session. So
all right, thanks so much, everyone. Really nice.
You're amazing.
Hope you enjoyed it. Good luck with the rest of the conference. Have fun.
Thanks, Oliver. Thanks again.
Thanks. Okay. Bye.
And
bye.
Thanks to everyone. Yeah, thanks to everyone for joining. Incredible chat today. And our next session is going to be an open chat, an open discussion, starting at 11. And we're going to look around how we can kind of increase our activism and share our practice. All right, so thanks again, everyone. I'll see you soon. Thanks, Oliver.
Bye.